I am George Orman and I am an associate in the employment team at Edwin Co. We regularly advise senior executives in relation to claims for discrimination, and today, as part of our Proving Discrimination series, I'm going to talk about sexual harassment and provide some pointers about what you need to do to help prove your case. The key elements of the legal definition of sexual harassment that you need to make out of bringing an allegation are that there has been unwanted conduct of a sexual nature which has the purpose or effect of violating dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. I'm going to run through the key aspects of the legal definition and then consider the sort of evidence and representations you should be making if bringing an allegation for sexual harassment. And, of course, if you are defending an allegation of sexual harassment, this will also be relevant for you. Firstly, the conduct needs to be of a sexual nature. What will amount to conduct of a sexual nature will depend on the circumstances of each incident of sexual harassment. Sometimes it will be obvious, sometimes it won't. It can include a wide range of behaviours, including but not limited to flirting or making sexual remarks, physical contact and touching, asking questions about someone's sex life, and displaying or sharing pornographic or other sexual content. Secondly, the conduct also needs to be unwanted. Whether or not conduct of a sexual nature will be considered to be unwanted is generally a subjective test. There may be circumstances where it is obvious that the conduct is unwanted. For instance, if an individual has expressly made the perpetrator aware that their conduct is unwanted. However, a victim of sexual harassment does not have to expressly object to sexual conduct before it will be considered to be unwanted. There is often a power imbalance at work, and an individual may be unable to expressly call out unwanted behaviour for fear of reprisal, particularly where the perpetrator is a more senior employee, for instance a line manager, and employment tribunals do recognise this. Finally, where there has been unwanted conduct of a sexual nature, it will only amount to sexual harassment if the conduct has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, etc. environment. The first part of this test, the purpose, relates to the intention of the individual carrying out the unwanted conduct. In other words, can it be shown that the person who carried out the unwanted conduct of a sexual nature did so with the intention to create a hostile, intimidating, etc. environment? It is often difficult to prove that the perpetrator intended their actions to create such an environment. However, this is where the second part of the test, the effect of the conduct on the victim, kicks in. When considering this part of the test, it does not matter what the perpetrator intended to do, wanted to do, or even thought what they were doing. What matters is how it made the recipient feel. This is a subjective test, and it is therefore important to carefully consider and keep a record of how unwanted sexual conduct made you feel, so that this can be used as evidence to prove sexual harassment took place. An employment tribunal will then look at the overall context of the matter and consider whether it was reasonable for the victim to feel the way they say they were made to feel by the conduct in question. That's an objective test. Some other general points to note. Sexual harassment also arises if a perpetrator treats an individual less favourably in circumstances where an individual rejects or submits to sexual advances or other unwanted conduct of a sexual nature. A single incident can be enough to constitute sexual harassment, and sexual harassment can occur if the conduct in question takes place outside the usual place of work, for instance at a work-related drinks, Christmas party, or work trip away. When considering this part of the test, it does not matter what the perpetrator intended to do, wanted to do, or even thought they were doing. What matters is how it made the recipient feel. This is a subjective test, and it is therefore important to carefully consider and keep a record of how unwanted sexual conduct made you feel, so that this can be used as evidence to prove sexual harassment took place. An employment tribunal will then look at the overall context of a matter and consider whether it is reasonable for the victim to feel the way they say they were made to feel by the conduct in question, which is an objective test. So what action should you take if you think you have been sexually harassed at work? Firstly, collate what factual evidence of unwanted sexual conduct is available to support your complaint. This could include emails, text or WhatsApp messages, or possibly CCTV footage. Make sure you also make a note of individuals who witnessed the inappropriate conduct, if any, who may be able to support your version of events. If you feel able to, tell the perpetrator that their conduct was or is unwanted and how it made you feel. If you do not feel comfortable doing this, then consider talking to someone else about what happened, as they may then be able to support a complaint even if they did not actually witness the behaviour in question. This could be to a colleague, friend outside work, a partner, a trade union representative, or someone in HR. In any event, it is important to make a contemporaneous record of any inappropriate conduct you have experienced, including time, date, location, etc. This record could take many forms, including but not limited to handwritten notes, an email to yourself, or diary entries, or something like that. When creating a record, don't limit it to the event itself. Make sure to set out why the conduct was sexual in nature, if not immediately obvious, and how the conduct in question made you feel. In other words, why the conduct created an intimidating, hostile, etc. environment for you. It may be that informal action, such as telling the perpetrator to stop what they are doing, is enough to resolve the issue. However, if informal steps are unsuccessful, you might consider raising a formal grievance. Your employer should have a formal procedure in place to deal with such grievances, and they have a duty to take your complaint seriously and to properly investigate the matters you raise in that way. Very often, acts of sexual harassment are carried out privately, and it is a case of one individual's word against another's. This presents particular challenges when trying to prove an allegation of sexual harassment. However, whilst arguably prior to the #MeToo movement there was often a presumption in favour of the accused, now that dial is starting to shift. This can be a complex and sensitive area of law. If you have any concerns about sexual harassment or discrimination in work more generally, or are raising a grievance and finding that stressful, please do reach out. We are experts in this field and are here to help.